From the nation's capital, the American Enterprise Institute for Public Policy Research presents Public Policy Forums, a series of programs featuring the nation's top authorities presenting their differing views on the vital issues which confront us. Today's topic, the press and the courts, competing principles.
I'm Peter Hackus in Washington. More and more, it seems, we hear of disputes between the press and law enforcement officials. Reporters are arrested, newspaper offices are searched, confidential notes are demanded for presentation in courtroom proceedings. Is all this a violation of the Freedom of the Press First Amendment to the U.S. Constitution? Will confidential news sources dry up if they feel their names might someday be revealed in court cases? Does the press have a special privilege in this area which should grant some kind of immunity not available to other segments of the population? What about the court defendant, on the other hand, seeking a fair trial as guaranteed to him under the Sixth Amendment to the U.S. Constitution? Doesn't he have the right to whatever information he feels might help in his defense, even if it means a reporter might have to reveal a confidential news source? Does the prosecution, representing the people, have a right to try to get any evidence that may help convict criminals? Welcome to another Public Policy Forum presented by AEI, the American Enterprise Institute, a nonprofit, nonpartisan research and education organization. Today's panel discussion topic is the press and the courts, competing principles. Appearing on today's panel are Jack Landau, Supreme Court correspondent for the Newhouse newspapers. Mr. Landau, also a lawyer, heads the Reporters Committee for Freedom of the Press. He has worked for the Associated Press, the Washington Post, and the Washington Star. Ralph Winter, the William K. Townsend Professor of Law at Yale University Law School. Professor Winter, an expert on the First Amendment, served as consultant to the Senate Judiciary Subcommittee on Constitutional Law. Professor Winter is an AEI adjunct scholar and a member of the AEI Advisory Council of the Legal Policy Studies Center. Edwin Yoder, editor of the editorial pages of the Washington Star. Mr. Yoder, who has worked for newspapers ever since he was 15, is a columnist for the Star. He is a former Rhodes Scholar with a degree from Oxford University and is a Phi Beta Kappa graduate of the University of North Carolina. Larry Sims, an attorney, is with the Office of the Legal Counsel at the Justice Department and has served as counsel to the Reporters Committee. Mr. Sims is a professor at the Georgetown University Law School in Washington. He once served as law clerk to Supreme Court Justice Byron White. John Charles Daly will moderate the discussion. Mr. Daly has served as a news correspondent and analyst for CBS and ABC News and as a vice president of the ABC network. For 2 years, he headed the Voice of America. Now, from the National Press Club in Washington, here is Mr. Daly.
This Public Policy Forum, part of a series presented by the American Enterprise Institute, is concerned with the relationship between the news media and the people through their government. Our subject, the press and the courts, competing principles. The basic relationship was set in concrete in the First Amendment constitutional guarantee of freedom of the press. However, the interpretation and definition of that freedom has been an emotional and contentious fact of life for 2 centuries. George Washington once wrote, "We have some infamous papers calculated for disturbing, if not absolutely intended to disturb the peace." Andrew Jackson said some editors appear to fatten on slandering their neighbors and they hire writers to lie for them. President Woodrow Wilson wanted to set up a federal publicity bureau to give the people the real facts because, he said, the regular papers played up differences of opinion and forecast difficulties, thereby impeding the public business. The special place of the press, all news media in our society, is often explained by Thomas Jefferson's declaration that, given his choice of a government without newspapers or newspapers without a government, he would opt for newspapers without a government. The same Thomas Jefferson, however, once said that newspapers ought to be divided into 4 sections: true, probable, possible, and lies. The smallest section, he added, would be that labeled true, and by far the largest section would be simply and plainly titled lies. Now, this capsulation of conflict at the summit between government and the press as the nation was born is symptomatic of the struggle which runs through the warp and woof of our society, public and private. Inevitably, the issues land in the courts, where the competing principles must find balance. So, Mr. Landau, the Reporters' Committee for the Freedom of the Press, of which you are a leader, has urgently sought to educate the public to the dangers to press freedom. How do you respond to charges that what your committee advocates is really special privilege or special interest legislation on behalf of the news media?
Well, I think special interest is all relative. First Amendment says, Congress shall make no law abridging the freedom of the press. In the past 3 months, we have seen the Supreme Court say that the police can march into newsrooms with a search warrant without any notice and rifle through the whole place on the pretext of looking for a document. We've had the New Jersey court say that more than 5,000 documents, virtually the entire file of the New York Times, can be seized and seen by a judge and possibly then turned over to the defense. And we've seen the United States Court of Appeals say that government may secretly seize up to 6 months of a newspaper office's telephone records, which of course are a profile of everyone they talk to. Now, if they can march into your office unannounced and rifle through your files, if they can seize your files en masse, and if they can secretly monitor your telephone calls, it seems to me quite clearly that Congress is abridging the freedom of the press, that that's what it amounts to. And I think that the First Amendment today is probably under the most severe attack it's been under, certainly in recent years.
Professor Winter, the thrust of the first 10 amendments to the Constitution was to protect the rights and freedoms of all Americans. Is new congressional action needed to recognize the press's special function and yet assure the fundamental rights of others?
Well, I think as the law presently stands, that the press is fully protected in publication. I think that has been demonstrated in case after case, no matter how often the justices on the Supreme Court are replaced by new justices, to the extent that the law presently allows unnecessary intrusion into the workings of the press, unnecessary in the sense that no particularly important governmental interest is served by the intrusion. I think then the press is deserving of freedom. But it does seem to me that the claims that we've been hearing lately about an absolute privilege in the case of the press, no matter how important another interest calls for a minor intrusion, that those claims are very hard to justify. I think that it is certainly as hard to justify an absolute privilege in the case of the press as it is to justify it in the case of a president of the United States.
Mr. Yoda, as an editorial page editor, public issues and public policy are your special province. In your view, does granting newsmen a degree of immunity from official inquiry threaten to bring with it the danger of broadened government regulation of the media?
Well, I've thought from the beginning that it would be a very serious error for the press to seek special immunities, legislated immunities particularly. I certainly have no objection to the extension of certain immunities by appellate courts on consideration of the constitutional claims involved, but I'm very skeptical of special immunities conferred by legislation. And I suppose my most fundamental reason for being reluctant to seek or endorse that kind of immunity is that it seems to me that what a legislative body gives, it can subtract, and even perhaps subtract to the degree that there's less there than was there to begin with, and that's why I'm fundamentally skeptical of that.
All right, Mr. Sims, you counsel the Reporters' Committee for Freedom of the Press, and now you're an attorney advisor in the Office of Legal Counsel in the Department of Justice, and you also teach a free press seminar at Georgetown University. From that very broad base of experience, let me ask, does the present relationship between the news media and the public interest serve us well, or is change necessary?
I think that the present relationship, which is one of within most of the press, a good, healthy one of serving the public interest and being very conscious of what the public interest is working quite well. I think that any statistical analysis of the facts would indicate that in the great majority of cases, the press, for example, is very cooperative with law enforcement efforts both on the federal level and the state level, because they recognize fully that they are citizens and they have no trouble stepping out of the role of press and doing their civic duty. I think that a lot of the recent controversy comes out of cases which lawyers and judges alike recognize as hard cases. And I think that it's dealing with those hard cases when the press finally gets to the point where they feel the line should be drawn, that we need to focus our attention without completely losing sight of the fact that the press does serve the public interest, and they do make these judgments in the editorial room and in the press room when they go to print their stories.
All right, gentlemen, let's come to grips with perhaps the two most recent major events highlighting the press and the courts. Mr. Landau, Zurcher et al. Versus the Stanford Daily et al. Brought you to the Senate Judiciary Committee to testify for the Reporters Committee for Freedom of the Press. You spoke to support 5 Senate and 6 House bills on proposed legislation to reverse the Supreme Court decision in that case. Would you briefly outline the issues and the dangers to press and public freedoms that you saw?
Well, the facts in the case are fairly simple. There was a political demonstration, I believe it was in April 1971, at the Stanford University Hospital, and the demonstrators got into a scuffle with police, and there were some photographers from the student newspaper, the Stanford Daily, there. In an effort to identify who scuffled with the police went to a magistrate, as they are entitled to do, and obtained a search warrant telling the magistrate that they had probable cause to believe that the newspaper had some documentation that would help them in their investigation. And without any warning, just showed up at the door of the newspaper. And there is some dispute as to what happened next, but apparently from at least the photographs the newspaper took, you can see the police looking through documents and desk drawers and things like that, which they're entitled to do. They were entitled to go through the whole place. They never did find the photographs, and the Stanford Daily then filed a lawsuit and said this violates our First Amendment rights, and they argued not that the government could not ultimately obtain the photograph it was looking for, but only that the government should have given the newspaper notice, that is, served a subpoena to the newspaper, let the newspaper come to court and argue whether the police needed that photograph. The newspaper argued that otherwise, the police just show up at the door and rifle through the whole place, seeing everything, confidential memoranda, correspondence, notebooks, on dozens of stories, having nothing to do, of course, with that case. And the Supreme Court ruled that not only newspapers, but no one else, who, by the way, are not suspects in the crime, these people were just third parties here, is entitled to notice, and that the police can just, if they want to, get their warrant and go into anybody's house or any office and go through the whole place looking for what they want. Now, there are some things which Mr. Sims will point out to you as perhaps moderating factors. And there are 13 bills in Congress now to reverse that. Some of the bills would only restrict federal search warrants. Some would restrict both federal and state. Some of the bills would only apply to the press. Some of the bills would apply to everyone. Our committee has supported the concept of a bill that would restrict both federal and state search warrants and would protect everyone, not just the news media.
Mr. Sims, would you like to give us some moderating circumstances?
I think that the Stanford Daily case is, among other reasons, a hard case because of a critical fact which was given prominent attention in Justice Powell's concurring opinion, which was that before the police went to get their search warrant, the Stanford Daily had announced that it would destroy any evidence of possible criminal activity if it had any notion that the police were going to come after it. That is a sort of a throwing down of a gauntlet to anybody who is the least bit interested in enforcing the criminal laws. Indeed, destruction of evidence is itself a criminal offense. Certainly, Mr. Farber has not advocated that. He's willing to go through the court processes. My experience at the Reporters Committee indicated to me that an overwhelming majority of the press is perfectly willing to go through that process. The Stanford Daily indicated in advance that it would not do so, and I think that that may have well been a very influential fact that caused that case to be decided the way it was.
All right, now that, I think, outlines the details involving the Stanford case. Mr. Yoder, your paper, the Washington Star, has editorialized on the issue of the Farber case. Would you be good enough to briefly outline the issues in that case and the dangers that you see inherent to the freedoms of...
Well, Mr. Farber is a reporter for the New York Times, to be very brief about it, whose stories approximately 10 years ago about some mysterious hospital deaths in New Jersey are thought to have led more or less directly to a revival of interest by the authorities in New Jersey in the case, and subsequently the indictment of a New Jersey physician who is charged with having charged with murder in connection with a number of these hospital deaths. Inasmuch as Mr. Farber's stories are thought to have been instrumental in reviving the case and leading to the indictment, the defense in the case has asked the judge for access to Mr. Farber's notes. Mr. Farber refused to turn over his notes, which were demanded in toto for an in-chambers inspection by the judge to determine their possible relevance to the defense case. When Mr. Farber refused to turn the notes over, of course, he was held in contempt, as was his newspaper. And the issue there, fundamentally, it seems to me, has been twofold. One, the simple fact that Mr. Farber was placed in jail and fined, as was his newspaper, rather severely, without what anyone, I think, who could look at the case as an impartial observer would regard as a satisfactory hearing of his constitutional claims, or indeed his statutory claims, since New Jersey has a so-called shield law. And also, in the matter of the judge's order for Mr. Farber's notes, the refusal of the judge to specify precisely what the possible relevance of the notes might be, where in the notes or what part of the notes might be relevant to the case and in what sense they might be relevant. It was just a blanket insistence that he turn over all of his files and notes on the case to the court for the court's private inspection to determine its relevance. And that has been the sticking point from the point of view of the press.
Professor Wood.
I'm not as sympathetic with Mr. Farber's case. I think he had a hearing on his claims. The New Jersey Supreme Court has held, so far as I can understand from the papers, the New Jersey Supreme Court has held that the guarantee of a fair trial outweighs whatever claims Mr. Farber has. And so far as the judge refusing to specify what part of his notes are concerned, that strikes me as being rather a red herring. The judge can't do that. If you're to impose that kind of a requirement, that's saying, well, you're really not going to let them look at it. You can't tell what notes you want unless you know what notes are there. If you were asking for notes that were unrelated to the particular murder trial, I think you would have an excellent point. But it seems to me that the request that they be handed over to a judge, that the judge look at the notes, decide whether any of it is of any help to the defense, is not a particularly unreasonable requirement when somebody is really on trial for his life. If Farber does not have to turn over his notes, defense counsel for the defendant in that trial ought, and I assume will, move the court for a judgment of acquittal on the grounds that the defendant has not had a fair trial. It seems to me that you have to decide what you're going to do in cases like this if you uphold the privilege, an absolute privilege. Are you going to let the defendants then go free on the grounds that they haven't had a fair trial? In addition to that, the Farber case is raised in an interesting way, an issue that shows how it is distinct from a lot of other privileges that the law knows. If someone comes to me as an attorney and requests my advice as to how, as to their legal liability in a particular case, what they tell me about the case is almost always privileged. The privilege, however, is that of the client, of the person who came to me. And I can't go before a judge and say, I'm not going to tell you, Judge, I invoke the privilege. I have to tell the judge that the clients invoke the privilege. In the case of the reporter, you never know who the source is. You never know where the information came from ahead of time. So it's the reporter who invokes the privilege. It's the reporter who decides what will be known, what will not be known, when it will be known, and what form it will be known. And in the case of Mr. Farber, I understand he's writing a book. It would be a heck of a thing, I put it to you, if 4 years from now, when the defendant is languishing in a New Jersey prison, the book is written and stuff turns up in the book that would have been relevant to the defense of the case, even if it doesn't identify the source. It just says a knowledgeable source said such and such. Or if, which is quite plausible in any situation like this, I'd be astounded if it didn't happen. I would think Mr. Farber was in league with the prosecution if it didn't happen, that his subsequent book had theories about the case quite at odds with the prosecution's theory about the case. And it seems to me if they're based on evidence that's in the possession of the reporter, then that kind of evidence ought to be made available to the defense to the extent that the judge can sanitize it and protect sources and the like. He ought to do it. But if it's not made available to the defense, then it seems to me the alternative is that you can't put a person to trial.
Am I wrong in thinking that Mr. Farber has offered to turn over, or did at one stage offer to turn over the manuscript and notes on the book to the court?
You offered to turn over the manuscript, I believe.
Right.
So far as it's been completed.
Right.
Well, that's different from saying he's turning over the book in the way it will seem.
What interests me is that here you have an independent institution, namely the press, without which it seems the lawyers, prosecutors, judges, and so forth simply seem unable to get along to discharge their functions and duties. And if indeed the prosecution in New Jersey can't make its case against Dr. Jaskelevich, if I remember his name correctly, if it can't make that case satisfactorily without dragging the press in, or if the defense can't make a satisfactory case without bringing the press in, then let the case collapse. I think it's much more important that these values of the independent institution of the press be upheld and preserved than it is to have successful prosecutions and trials. That's my point of view.
Doesn't that result strike you as a bit odd? That Mr. Farber goes out and writes a series of articles saying Dr. X has murdered a large number of people. And as a result of the articles, Dr. X can't be tried for murder?
I think it's somewhat ironic, as Mr. Yoder points out. Here you have one newspaper reporter, right, roaming around New Jersey. And here you have the whole state of New Jersey with its judges and marshals and subpoenas and search warrants and all the power of the state. And they can't get what they want, they've got to go after this one reporter. And that, by the way, has been the pattern in these cases. In case after case, you know darn well in the Stanford Daily case that the Palo Alto police, if they wanted to, could have found one of those 300 demonstrators who could identify somebody who attacked the police. But what do? They go against the press because it's convenient, it's easy, and because we do our job well.
Well, don't confuse the Stanford Daily case with the Farber case. They don't have sheriffs and the police and everything running around to get Mr. Farber. The defense wanted access to the information. It's the only reason anybody's going after it. That's a very different situation, and I agree with you, than where a prosecutor goes out, and particularly with a search warrant, tries to get to a newspaper's files. And there's a lot of reasons for the difference. One is that the prosecutor is likely to be a political figure who may have particular antagonisms with the press and may be interested in getting information other than what's listed in the search warrant. The prosecutor may be a person who's been criticized by the press. There's all kinds of room for abuse. I agree with you when a prosecutor seeks to get into the press's file. I don't mean to say I'd go with an absolute privilege, but that's very different than a situation where Mr. Farber, one way or the other, has the prosecution's file, conducts an investigation, directly leads to the prosecution of an individual who says, I would like to see all the evidence that's available against me and not read about it while I'm in prison. And then you have the judge in between who will read the material in private and will turn back anything that isn't necessary to the defense.
Why doesn't it offend you that people are in jail all over this country and they probably could be acquitted if lawyers produced from their files information covered by the attorney-client privilege? Why is it, may I ask, a cosmic disaster if the exact same privilege is claimed by the press? Why does the system self-destruct when a newspaper man claims the privilege, but not when a lawyer claims the privilege?
Jack, I think, let me interrupt here. I think that the information in lawyers' files, which is protected by the attorney-client privilege, would probably get people convicted rather than acquitted. And I think there may be a significant difference there. But I think with regard to the Farber case, that one aspect of it, which has gotten very little attention, which Ed really alluded to at the outset, is the existence in New Jersey of what at least I understand to be a virtually absolute Newsman Shield law. But I think that the real significance of the New Jersey Shield law, which apparently has been essentially set aside in the name of a fair trial, is that the political organs of the New Jersey government, the legislature and the governor, have come into agreement that in the state of New Jersey, newsmen shall have an absolute privilege from disclosing the kind of information this judge wants disclosed and that the defendant wants disclosed. What that law should represent analytically is a decision by the political organs of government in New Jersey that the doctor, if the evidence is necessary, shall not be prosecuted. It's not the press coming in and saying that the doctor shall not be prosecuted. In this particular case, I think you have what at least is arguably a judgment by the representatives of the people of New Jersey that the doctor shall not be prosecuted if this evidence is necessary. What I find phenomenal about the case, this has happened in California too, as Jack knows, is that in the name of a fair trial, the courts have simply laid waste to the political judgments of state legislatures. And I think that is an absolutely indefensible act on the part of the court, because what the court is doing is it's saying that it's the court's decision that the trial must go forward, when in fact, analytically, what's happened is the state legislature has decreed that the trial shall not go forward under certain circumstances. And I think that may be the most outrageous aspect of the Farber case.
Have they said that it won't go forward, or it just will go forward without this evidence?
Well, I don't think that anyone is prepared. I'm certainly not prepared. I don't think any member of the press is prepared to say that people ought to receive unfair trials. The decision that has to be made is, as Ed really phrased it, whether there will be a trial or not. And the number of prosecutions that are aborted, I'm sure still on a daily basis by virtue of the exclusionary rule applied to keep tainted evidence out of criminal prosecutions must certainly be far greater than the number of prosecutions which, at least recognizing a shield law, would abort.
Apropos of the relevance of the shield law in New Jersey, I would like to make a query about something I understood Professor Winter to say in connection with the Farber case. As I understood the decision of the New Jersey Supreme Court, and I have not read the text of the decision, it's always hazardous to assume what a court has actually said from news accounts, I regret to say, but as I understood the reports of what the New Jersey Supreme Court had to say, it's held in effect that a hearing for Mr. Farber on the issue of the shield law was in effect pointless, inasmuch as Judge Arnold apparently was presumed to know the facts sufficiently as to the relevance of the shield law, so that in effect it was pointless for Mr. Arnold to be given an opportunity to be heard. Am I mistaken in that?
That's about what they said, yeah. Here's a statement by, I think it's Justice Holmes. In 1924, when a subpoena similar to this was served, calling for thousands of documents, and Justice Holmes said, it's just contrary to the first principles of justice under the Fourth Amendment to allow a search through all the records and files, relevant or irrelevant, in the hope that something will turn up. And I think that's an interesting parallel, that the Fourth Amendment protection against having your private papers seized en masse is precisely the same Fourth Amendment argument you would use under the exclusionary rule.
My understanding was that the founders of the American Republic were exercised, among many other things, in the tradition of the sort of colonial and revolutionary period by general warrants. Is that not the case, Professor Winter?
No,
and this, it seems to me, is nothing if not a general warrant.
Oh, I don't know about that.
Well, I mean, loosely speaking, of course.
In the Farber case?
Yeah.
No, I wouldn't think so. Not given the relationship of the prosecution to the newspaper stories and everything else. Very peculiar case. It's a very bad case, in my opinion, for the press to be raising. For one thing, I frankly think the problem of the fair trial, so far as compulsory process to get a newsman's files, would go away if the press didn't raise the issue. Because in most cases, a reporter could turn the files over to a judge, the judge would look at them and turn them back, and that would be the end of the matter. The minute they know the privilege is going to be raised in every case, the defense lawyer gets a freebie. He makes the motion. He has nothing to lose. The reporter's going to refuse to turn it over. And he's left standing there saying, well, my fellow didn't get a free trial.
I'm sure we'll come to further discussion of all these areas when we get into the questions and answers, and it is now time to open that question and answer session.
Jack Pelderson, political scientist. My question is, if the press have rights of speech beyond that of other persons, who decides who belongs to the press? Or why can't everybody claim to be a member of the press if they can write and put out a newspaper?
Well, I would respond to that by saying that if you're dealing with the question at a constitutional level, it's a very difficult question. The notion that the First Amendment is designed to protect Thomas Paine as the lonely pamphleteer, as well as the New York Times or an equivalent media outlet, I think runs pretty strongly in both the history of the First Amendment and in latter-day decisions, making those kinds of distinctions very difficult to make, I think, on a constitutional level. You also may run into hard cases. What happens, for example, when a terrorist organization sets up shop in the United States and starts its little press in the back room and claims the kind of constitutional privilege that was claimed in Brandsburg, for example, and that was claimed in the Stanford Daily case. Is the court then to take evidence on whether this is a legitimate press outfit? Is it to inquire into the motives of these people who claim to be the press? That's difficult. If you're dealing with it at the statutory level, either in Congress or in the states, I think it's fairly clear that as a matter of constitutional law, i.e. whatever equal protection notions may be present, and the recent Hutchins versus KQED case, I think brings that kind of notion very much to the fore. I think the legislature has, yeah, that's a case in which a somewhat divided court reaffirmed the principle that the press shall be given no special access, in that case to prison facilities under the First Amendment. But a concurring opinion of Justice Stewart, which is arguably the controlling opinion, at least in that case, it was a 7-man court that decided it, suggested that the free press clause, as opposed to the free speech clause, in some situations may require what may appear to be special treatment for the press, when in fact it's not special treatment at all. It's simply giving the press the tools to perform its function of communicating information to the people. And I think that, but getting back to your question, I think that Congress or a state legislature has a reasonable degree of freedom in defining the press narrowly to solve part of the problem, or what it may perceive to be a problem, without including all of the people who intellectually might be thought to come within the ambit of the press as a constitutional matter.
President Winter?
I think one of the great difficulties in defending a so-called special privilege for the press is that you cannot define it simply as the institutional press. I don't think people really would put up with a special privilege for media conglomerates, but not for people who want to publish handbills or law journals, if you will. I think the press includes all publishing. And it includes such a large number of people that if you try to give the kind of privilege that is occasionally talked about, not necessarily here, but is occasionally bandied about, it would be just intolerable. And I think this business of defining it is one of the really serious problems of any press privilege.
Mr. Yoder?
I emphatically agree with that. And I think there is an unfortunate tendency sometimes on the part of the institutional press to forget what the court historically has frequently reminded us, and that is that the freedoms tended by the First Amendment to the press include your right to publish a handbill just as much as our right to publish an uninhibited Washington Star. We had a very interesting case. I'm surprised that our fellow discussants haven't mentioned this, in the last term of the Supreme Court, in which the court upheld the right of a bank to place newspaper advertising, which was in effect political advocacy concerning a referendum in the state of Massachusetts on a state income tax law. There had been a half-baked Massachusetts law which sought to inhibit business and institutional advertising which carried some sort of political doctrine or message apropos of a referendum, and it was quite correctly, in my opinion, struck down by the court in a very interesting opinion. There was a concurring opinion by Chief Justice Berger which caused a certain ripple of excitement in the institutional press because he, again, went over some points that I think are quite self-evident about the claimed special privileges of the institutional press, and that is that the First Amendment really is essentially for everybody, and I welcome that kind of decision as long as it doesn't portend some curious twist of the law by the Supreme Court in the direction of curtailing the institutional press in the name of expanding the privileges of individual persons.
Well, I think that's right. I think Chief Justice Berger was not attacking the institutional press.
I didn't think he was either.
Well, what he was warning was that the law cannot remain in a posture in which you can prohibit people from buying advertisements, but you can't prohibit people from buying newspapers and doing whatever they want. That the two things are inconsistent, that you have to permit people to go out and use the press, to purchase advertisements where they can. And that is absolutely essential. There are all kinds of laws around the land now regulating how people can buy political advertisements and things like that. And if we ever get into the situation in which the only way you can use the press is to own the paper, I think we're going to be in a situation in which we will turn to remedies that more and more people are suggesting about breaking up the press, more control over it, extending fairness doctrine to the print media as well as to the broadcast media, where we all know it's a terrible threat of censorship right now. And I think that was a terribly important decision, and unfortunately it was a split decision, I think 5-4.
He touched a sensitive nerve, too, by pointing out that if you get into the question of who really is in control of this utterance of opinion, then you certainly, in the case of the established institutional press, many outlets and organs of which are now owned by conglomerates which control not only publications and publishing houses and in some cases baseball teams, but other interests. It's very difficult to distinguish between, let us say, CBS on the one hand, or the New York Times even, or for that matter, Time Incorporated, and the bank establishment in Massachusetts, which was prohibited from this utterance by the rather ridiculous Massachusetts law.
I think, just as this discussion shows, there's a misapprehension about the position of the establishment press. You must remember that the establishment press en masse supported a little university newspaper which was raided by the cops. And it was the establishment press that supported a little FM station in Los Angeles that wasn't allowed to say 7 dirty words. In fact, during the Shield Law hearings in 1973, all of the conceivable constitutional horrors were suggested. The mafia starts a newspaper, for example, says Senator Ervin. What are you going to do about that? But in over 200 litigated subpoena cases, there has never really been a question as to whether the person was a member of what everybody would consider the press. We did have a case in New Mexico, it was about 5 years ago, of a fellow who joined a picket line, and 20 minutes later he put the picket sign down and took out his pad and interviewed people, and then he put his pad back in his pocket and picked up his picket sign. And in all the cases that have been litigated, that's just about the closest that anybody has come to the question of whether a person, as a matter of fact, I think the district court there said he was a member of the press, although they thought his behavior was somewhat unconventional.
Well, I don't agree with that statement. I think all of the cases involving political advertising involve the press, and I also think that the establishment institutional press has not defended them. The institutional press defends owners of radio stations and owners of newspapers. The institutional press did not cry in alarm when Congress passed a law held unconstitutional saying people could not spend more than $1,000 purchasing. Well, your paper, the New York Times was solidly in favor of it. A lot of newspapers.
Distinguish, please, because
it is unfair. I've labeled but in truth, they defend owners.
Your argument, because that was against their own economic self-interest. To limit, I mean, if you limit political advertising, you limit.
That's another question.
I think if we got into that mare's nest, we'd be here the rest of the
month. We're not going to get into the dirty words case, I hope.
No, that one we'll leave alone, too. I think we better get on to the
because I may have to unsay many of the things I've said.
My name is Bruce Fein. I'm an attorney at the Department of Justice, and I would like to address this question to the entire panel. I see two problems in the wholesale substitution of subpoenas for search warrants in the conduct of criminal investigation. One, when you issue a subpoena, it does lead to the possibility of destruction of evidence. For example, a subpoena was used in part of the Watergate investigation, and we found some gaps later on. Second, subpoenas, if they are contested, can lead to a delay in compliance with a subpoena, and oftentimes time is of the essence, as newspapers themselves know, in getting access to information so that leads can be followed up. So it does seem to me that use of subpoenas could substantially curtail the effectiveness of some kinds of criminal investigations. Second, if they are put into a statute allowing use of search warrants, if the police can show that either delay or destruction of evidence is likely to ensue if a subpoena is issued, doesn't that create a problem of the police gathering dossiers on newspapers or individuals so that they can make the showing that a particular person or newspaper is hostile to the police and therefore would likely dishonor a subpoena?
Well, you want to start then, Jack? You testified to this point.
I can't sympathize with the delay. The orderly processes of the law give you notice and a right to be heard. What you're saying is, let me trample your rights and afterwards come in and complain to me. And if you're wrong, we'll give all the stuff back, having seen it. I can't sympathize with the delay problem, although I believe there may have been a suggestion that if there's a danger to life, as opposed to just a delay in the investigation, or a clear and present danger to the national security of the United States, that in those circumstances they might buy the delay argument. In terms of destruction of evidence, I believe every one of the 13 bills has a provision in it which would permit the law enforcement to obtain the subpoena if they can either allege probable cause that the person in possession of the information has committed a crime, or probable cause that the person in possession will destroy the evidence. So yes, I think your two worries on that score are solved by virtually every one of those bills. I think they all have the destruction, and most of them have the involvement in a crime. As far as your third one, I would only hope that law enforcement would not go around wiretapping us in order to prove that we perhaps might destroy evidence.
I think, Mr. Fein, you may well be wrong. My understanding is that until the last decade, search warrants were not used very extensively upon third parties. They were only used upon suspects. And then they were extended so they could be used upon third parties. And that's a very major change in the law. Getting a search warrant in most places in the United States, unfortunately, is no big deal. The police know which is the magistrate most likely to give it. They can put allegations in an affidavit without a really great fear of being prosecuted for perjury. If they're looking for harassment or to get information on sources in the press or things like that, they don't have to fear the exclusionary rule. A civil rights action against them is unlikely and unlikely to bring damages. And it seems to me, if you look at the ease with which you get warrants, the fact that it lets people go through everything, that we ought to have very, very severe restrictions on them. I really haven't thought it through. I might even be prepared to go so far as to say that what should have happened in Stanford Daily was a subpoena. If they didn't get the photographs, perhaps a prosecution for suppressing evidence of a crime or whatever, if there was evidence of a crime. That might raise a different issue, although I must say in the case of photographs, I can't see any serious chilling of the press unless you say a reporter has an independent interest in seeing people get away with a crime. I mean, it's not like talking to a source. But search warrants are a very dangerous business.
It seems to me that the interests involved here are so asymmetrical that it's really absurd to say that you establish a precedent permitting what one newspaper called the right to rummage a newspaper office, and inferentially perhaps the right to rummage the offices of other people in search of evidence, though they are innocent parties or presumed to be innocent parties, and for what in return? A picture of some demonstrator giving a black eye to a policeman. What a total asymmetry of interest is involved here. I think the underlying assumption of the question is that efficiency is a supreme value in our constitutional system. It may be in some cases, as in the case of when life is demonstrably endangered, or when by some immense jeopardy to national security, life may be inferentially endangered. But to get a photograph of a policeman being socked by a demonstrator seems to me pretty small potatoes, in exchange for which to throw away very, very important rights of privacy and very crucial protections against search warrants.
All right, next question, please.
Julius Shea, the Washington Journalism Center. I'd like to ask both Mr. Yoder and Mr. Landau whether they think the court's reaction to the press these days reflects the general feeling in the country that the press has gotten too big, too monopolistic, and so forth. Mr. Yoder's paper is now owned by Time Inc., one of the big media conglomerates in the country. Mr. Landau works for one of the big groups of newspapers, the Newhouse papers. And we all know judges are people too and tend to reflect the feelings in the country.
Which one would like to start? Beck, you're up in the wing.
Well, he's the philosopher.
All right, Mr. Yoder, you're the philosopher. You start.
What I have to say about that will be quite unphilosophical, I'm afraid. Of course, Mr. Duché, you're asking for speculation about the state of mind or suspicion of Supreme Court justices and other judges. I could speak with more information about the state of mind of some other lower court judges, but I would not venture to speculate about the justices of the Supreme Court. All I would say is that if their recent pronouncements, at least by tangential reference and so forth, indicate a state of skepticism and maybe even some alarm about the increasingly monopolistic structure of the press, I would not be surprised, and if it does, I think it would reflect, notwithstanding the anomalous situation of my saying this in view of my own connections, I think it's well warranted. I think it's something that everybody should be concerned about. I think it's also important, of course, for people to understand, as I think all too few people do understand, that very many of the recent tendencies towards agglomeration and monopoly in the press are to a very great degree dictated by economic circumstance, by technological circumstance, by social factors and changes in the country that really do not make it the result of a deliberate conspiratorial process. I take exception to that interpretation of it. But I think if they do reflect some of that suspicion or alarm, it's probably warranted. Not that it should affect the interpretation of the First Amendment.
I think that there is a certain hostility in the court, not only the Supreme Court, I think other courts too, toward the press. I tend to think, though, that in one sense we're talking about apples and oranges, Mr. Duché. What the Supreme Court sees in Washington is very affluent, superbly equipped, generally very well trained, enormous corps of reporters all over the place, with bureaus and big expense budgets and that type of thing. The cases, though, involve the little FM station from California and the reporter from Virginia and that type of thing. I don't think they really understand how difficult it is to be a reporter, especially on the local scene where most of these cases arise. And I think that they sort of transfer, in a sense, what they see is this very, to some degree, arrogant, affluent press establishment in Washington, and don't realize that what we're talking about is the weekly reporter who may be the only investigative reporter in the county. And if he's thrown in jail because people, or discloses his sources because people won't talk to him, that's the end of any investigation in that county. And I think that there really is a big distinction in the points of view between what we're trying to tell the court about the news business and what the court is convinced it thinks it knows about the news business.
Just to be fair, though, Jack, to the court, let's not really suggest that all of these people on the court see eye to eye, either on the principles of the press cases that come before them, or indeed in their personal views of the function of the press. And to some degree, I suspect there may be a correlation here. I certainly would think that they are no more of a piece in their views of the press than any given group of 9 well-informed and responsible people would be likely to be. In fact, I would be willing to bet that they're not.
All I was trying to point out is I think that there's a different perspective here.
Sorry.
Next question, please.
Jim Toothman. I'm an attorney practicing in California. And as to those members of the panel that take the position that some power less than an absolute power of the press should exist, my question would be, do you draw any distinction between a review by the police and or a prosecutor of evidence or information and a review by the court, particularly a lower court, of information to determine whether or not that information is in fact material to the issues that happen to be before that court, and how that evidence and or information may relate to a violation of that individual's rights?
Landau?
Well, I think the position that we take pretty generally is that a judge is the government. He's one of the three branches. And if we won't give it to the prosecutor or we won't give it to the governor, we're not going to give it to the judge. And that's, of course, part of the fight in the Farber case over the in-camera inspection question. The New Jersey Supreme Court, of course, judges all think, that they are somewhat more sensitive than anybody else, and so they have a right to see it where nobody else has a right to see it. But I might point out that even in the attorney-client privilege cases, once the court finds that the privilege has been properly invoked, there is no in-camera inspection of your client's material. There may be an in-camera inspection to see if the privilege was properly invoked, but if they agree that the privilege was invoked, nobody gets it. So I think the press is on fairly sound ground, but especially because of the advocate position of the press and the courts. And you must remember in the Farber case, one thing that really hasn't come out is this case was written because the courts and grand juries in Bergen County didn't do their job in the first place. And there are lots of folks out there friendly with those judges of the same political party who ran on the same tickets who had their ears burned as a result of this investigation.
All right, this concludes another public policy forum presented by the American Enterprise Institute for Public Policy Research. On behalf of AEI, our heartfelt thanks to the distinguished and expert panelists, Mr. Jack Landau, Mr. Ed Yoder, Mr. Larry Sims, and Professor Ralph Winter, and our thanks also to our guests and experts in the audience for their participation.
This public policy forum on the clash between the press and the courts has brought you the views of 4 experts in the field. It has been presented by AEI, the American Enterprise Institute. It is the aim of AEI to clarify issues of the day by presenting many viewpoints in the hope that by so doing, those who wish to learn about the decision-making process will benefit from such a free exchange of informed and enlightened opinion.
This Public Policy Forum series is created and supplied to this station as a public service by the American Enterprise Institute, Washington, D.C. For a transcript of this program, send $3.75 to the American Enterprise Institute, 1150 17th Street Northwest, Washington, D.C. 20036.